Can I modify our petition to modify a final court order about child custody or child support? What are those circumstances for child custody? Attorney Eric Bates explains. A final family custody order is unlikely to be modified before the passing of 2 years. The only way you can really get around that is if there's some emergency situation. If the children are in danger in some way due to the actions or behavior of a parent, then the court will hear that and make a decision. But generally, if you have a custody order in place, you're stuck with it for 2 years. Now, that doesn't mean that you can't go to court for anything. For instance, if there's a custody order and the father is not following it, the mother can go back to court to try and hold him in contempt for not following the order. Therefore, you don't have to take situations like that for the next 2 years. But if you established joint custody and then decided you want sole custody, you're not likely to be able to file and argue for that until at least 2 years from the date of the original order has passed. In regard to child support, there's nothing that would prevent you from filing it. However, courts aren't really going to look at modifying child support unless there's a real change in income. For example, if I'm paying a lot in child support, but then I lose my job, that could prompt a substantial change in circumstances that would allow for a modification if I get another job that makes 10% of what I had been making. If it's a substantial enough change in income, it justifies a change in the child support order. The judge is probably going to hear it and consider it. For more information, an initial consultation is your next best step. Get the information and legal answers you are seeking by calling us today or visiting our website at www.bateslawoffice.net.